Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Judge. How are you?
I'm good. How are you?
Good. Good to see you.
You too. Yeah, I haven't seen you in a while.
Yeah, it's been a while. It's my turn came up in the rotation.
Oh, good. Okay. All right, let's get started. Good afternoon, ladies and gentlemen. I'm Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we're able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. And what is the SAP reset date?
It's going to be May 18th.
Okay, May 18th is the reset date. I want to advise everyone that this whole entire proceeding is being live streamed, and it is also being recorded on YouTube, live streamed on YouTube and recorded. So govern yourselves accordingly. I want to remind the defendants that you have certain constitutional rights, the first being that you have a right to have counsel at this hearing. Most of you should know who your attorneys are by this time. Also, I want to remind you that you have a right to remain silent. Anything that you state about the facts and circumstances of your case can and will be held against you. All right, who do we have first?
Position 3, Ms. Hayward.
All right.
And I had requested a breakout room to discuss some of the facts with the state and the court.
Oh, let's see. Let me look at my messages here. I forgot to look. Breakout with position 8. Oh, that's Mr. Bartels. And position 3. And then we have another request. We have to make sure that we do what Deputy Falk tells us, and she wants hers to go first because she obviously has something that she needs to do as well. So can we try to accommodate her? Did you get that message? Deputy Nars?
Yes.
And
Case
Your
is
Honor,
that, Your Honor?
thank you for the accommodation. I will. I mean, obviously the breakouts take precedent, so I will be here.
Right. She needs to do 1, 2, 3, 4. Oh, no. Positions 2, 4, 5, 6, and 11. So as best we can we do that to understand we want to?
Yeah, we're going to do it. So, yeah.
Okay.
Yes, ma'am.
Okay. And so 3 is a breakout. Do you want to do that now or at the end?
At the end. We can do it.
That's not one of Deputy Falk's.
Well, Deputy Falk generally goes in the breakout rooms, so.
Oh, that's right. We need her. Yes, we do. I'm trying to accommodate you so much and hurry up. So I guess we can go ahead and do 3 and get in the breakout, and then we can come back and take up her others.
And
Can I go in the breakout room as well?
Yes, Your Honor, can we discuss both cases in the breakout?
Yes, let's do that.
Okay.
It's 3 and 8.
Sure, and also on number 8, his mother is on standby. I think she's going to come in before we start doing his case. So just to let everybody know.
She's down at the jail.
She's one of the ones who got to do breakouts, so we're going to do them first. But she's not on here though.
Well, I will not have the mom in the breakout, but if I need to hear anything from her when we come out of it, I may let her speak. I may not.
I'll let her know when we're coming out of the breakout room.
Okay, that's fine. All right, put this in the breakout, Miss Champion. I think All right, we're back on the record.
Yeah, and Judge, it does look like Ms. Quiggle is here. I think I see her name.
Okay, Ms. Quiggle.
Yes.
All right, we're going to hold for a second. We're getting some information and then we'll start your son's case.
All right.
Okay, so hold with us for a second. We're going to do a couple of others and then we'll come back, okay?
Thank you.
All right. So we want to start with position 3.
Yes, ma'am.
Okay. All right, this is 23 CR 0002773J. State versus Hayward. Charge of 1 count of criminal trespass and damage to property, 1 count of battery, family violence. Offense date May 3rd, 2023. And is the victim Miss Judine on the Zoom caller at the jail?
I'm sorry. Say that again.
Is Miss Judine on? Is she down at the jail? Is she on my Zoom? I don't think. Miss Judine, did you all say she was down there or no?
No.
Believe she's,
Okay. Say that again, Ms. Wills.
I don't believe she's present by Zoom or in person.
Either way, okay. All right, I was just sounding for her just in case. I thought maybe she was here. All right, Ms. Hayward, we have spoken about your case and some of the concerns from both sides with this matter in our breakout room so that we don't disclose some of the confidences on this recording. And what we've come up with is I am going to order a $5,500 surety bond, which is $500 on the battery. I'm sorry, $5,000 on the battery and $500 on the criminal trespass for a total of $5,500. And I'm going to order you to stay away from 311 Scott Street Southwest. And was that apartment 177?
Yes.
Correct.
Okay. And I'm going to order that you have no further contact with Miss Judine right now until we can get matters a little more under control. This just happened yesterday. We want there to be the proper cooling off period so that everyone can begin to get things back together at the home. So you will have to stay somewhere else in the meantime, and while you're on bond, till you get an order that says differently. Gonna order no drugs, alcohol, or weapons while on bond. And I guess that is it. What did I leave out, counsel?
The state is okay with the one-time escort.
Oh, okay. Let's also, I'll order a one-time law enforcement escort back to the property to get any personal belongings that you may need. But please, Ms. Hayward, do not go back without law enforcement. So you can schedule that when you get out to go back to get some personal belongings to have with you wherever you may end up staying until we can resolve this matter, okay? All right, that should conclude this case.
Position, see right there. 4.
Okay. This is 23 CR 002774C. Is that Jaganga or Jagana? I'm not for sure how to pronounce the last name. I apologize.
That's correct, Judge. Paul Roman for Mr. Jagana.
Jagana, okay. And that's Paul Roman, okay? This is a case with the charge of battery, family violence, and cruelty to children, third degree, offense date, May 3rd, 2023. Pre-trial.
This is fourth arrest. Last arrest was 05, reproduction of recorded material. That's it.
All right, state.
Your Honor, what position is this?
Position 4.
1 second.
And
Okay.
number 2 bonded out. They put it in the
Oh.
check when y'all were in the breakout.
Oh, okay. Thank you.
One second, I beg the court's indulgence. I'm just checking something really quickly.
Okay.
My apologies. I'm here. I was on the phone with Miss Corley from MMC. So she did
Right.
give us a response, and I went ahead and put that in the chat to you and Mr. Bartels.
Great.
Yes.
This is Mr. Jagana's case.
Yes.
This incident happened May 3rd, 2023 at 8264 Millen Loop in South Fulton. When officers met, they actually encountered the defendant first. He stated that his wife, Aminata Jagana, was not acting right. Contact was made with Miss Jagana, who stated that they had argued about their children not going to school. The defendant grabbed her by her neck and held her onto the floor. Miss Jagana said she tried to push him away and ended up biting his finger. 12-year-old AJ, who is the child of Mr. and Mrs. Jagana, who called 911, stated that she didn't know what the fight was about, but she saw her mother being held onto the floor by her father and called 911. Miss Jagana did have 2 red bruise marks to the right side of her neck. And the defendant actually admitted to choking Miss Jagana, but claimed it was a way to defend himself from falling downstairs. So not exactly sure what that means or how that can help you from falling down a flight of stairs by choking someone. So the state's recommendation on this one is a $5,000 surety bond, stay away from 8264 Millen Loop in South Fulton, no further contact with Miss Aminata Jagana, and the 12-year-old victim here, AJ, no alcohol, drugs, or weapons. Our main concern here is the level of violence employed. The fact it was employed in front of a 12-year-old child is especially problematic. No 12-year-old child should have to be in the position to have to call 911 to get help for their father abusing their mother. So this is a particularly fraught case, and the state does have serious concerns about a risk of reoffense. We also have recommended this case to the DA's office for possible evaluation as a felony upgrade. The state would like to sound for Ms. Jagana.
All right, Ms. Jagana. Don't think I see Ms. Jagana on the Zoom line. All right, Mr. Roman.
Yes, Your Honor. My client is 47 years of age. He is the father and sole provider for 5 of his children. He's been happily married for 19 years with Aminata. She reached out to me this morning indicating that she absolutely wanted him to be able to bond out and have no violent contact as a provision. She did indicate that nobody from the state had spoken with her at all about what her request would be on the case. And I generally object to any sort of, statements being made without the proper review at this time. Your Honor, he has no criminal record to really speak of. The no violent contact provision is sufficient. The mother of his children and wife has spoken. I would ask you to set a bond of $1,500 regular surety bond on each charge.
And Your Honor, I would like to respond to Mr. Roman's contention. We did attempt to reach out to Ms. Jagana. We actually ran a clear search because we did not have her phone number as part of the warrant, as often is the case. We ran a clear search. We reached out to every number we had available and did not receive a call back. So it was not for lack of state's efforts that we were not able to speak with Ms. Jagana. It was just simply for the situation that we are placed in every case where we have a warrant sometimes and do not have contact information, which makes it difficult.
Okay. I want to, first of all, make sure that there's been the proper cooling down period I am concerned about the allegations, and I do know they are just that at this point, allegations, but they are concerning to me. And I'm going to order the $5,000 surety bond. That will be $3,000 on the battery and $2,000 on the cruelty, for a total of $5,000 surety bond. I'm going to order a stay away from 8264 Millen Loop in South Fulton.
Judge,
And-
if I
Okay.
may, that's where he lives, and she's indicated, if I could possibly get the phone number to victim witness or somebody that can confirm what I'm saying as an officer of the court is true.
That she will not reside there?
No, that she wants him back home. She can't handle the 5 kids by herself. That's where he lives. There's been no prior incident with this marriage in the last 19 years. So I'm not sure where the state is assuming that there's going to be some sort of follow-up incident. There's never been anything up until this point, and he is 47 years of age. So before we go assuming what the victim wants, I can provide the phone number for Aminata, that's her name, and let somebody reach out to her and confirm what I'm saying is true.
Just to be clear, the state doesn't doubt Mr. Roman's contention, nor does we doubt his statement as an officer of the court. We are assuming everything he is saying is true. That does not deny the fact that this happened about less than 36 hours ago. And so the state's concern for a lack of cooling off period here, and the fact that there are cycles of domestic violence where victims often ask for contact, does not change the state's recommendations.
Well, then I recommend if that we give it 48 hours and he can return to that address, no violent contact. That's where he lives, and she needs the help with the 5 kids. They range in age from 18 months to 12 years of age.
Yes, we're aware. And the 12-year-old is the one who called 911 for this
Okay,
incident.
well, that's what I'm merely expressing what she has asked me to represent.
And I understand, and the state's recommendation remains the same. Thank you.
Yeah, I wish she would have been able to, I know she has some small children, obviously, to have spoken to the state or come on to the Zoom call.
Well,
And I don't know if that would change my ruling, but I would like to hear from her. But we also want to make sure, as a victim of domestic violence, that she is not put in any more danger in less than 36 hours of this incident that is alleged to have happened with the child, who obviously was in fear for their mother, who called the police for help. That's pretty serious. It's pretty important. And we certainly don't want to diminish it just because it's the father. It can, happen between married people. It does a lot. We see it every day. And we need there to be that separation, that cooling off, to make sure that the mother and the children are going to be safe. We need to protect the victim. And so that is our role. Mhm.
I just thought maybe it'd be important, if you're going to make during the pendency of this case, if you're not going to allow him to return to his home, that this could go on for quite some time. I'm not
Well,
sure
you do,
where-
yeah, you have the
to cool
ability
off.
to apply for a modification of the bond conditions if we find out otherwise, or that something has changed from these initial allegations that the court needs to consider. And I get them all the time, motions for bond modification, and we entertain that and have the hearing scheduled and bring the case back in a week or so, whenever you want to do that. And obviously we can have her to testify at that time.
Well, can I have the opportunity to give somebody the phone number so they can confirm themselves without the necessity of another hearing?
Well, if victim witness from the solicitor's office has someone that is able to do that, I don't know. I'm not 100% sure, and I'm not going to guarantee you that it's going to change my opinion.
I'm not saying
But
it will.
But
or
if
will not.
they you know, that'll be up to them if they want to get a better phone number to call her at.
Okay.
Miss Deputy Falk, do you want to do that or not?
Your Honor, I feel like I really made myself clear on this, but I will repeat myself. Regardless of the Ms. Jagana's statement that she wants this defendant to return to the home, we aren't opposed to it. We are more than happy to talk to Ms. Jagana. We're more than happy to hear her say that herself. Again, I do not doubt Mr. Roman's contention. It does not change my recommendation.
And if you want, you can do a direct message to Deputy Falk in the chat to give them the updated number or the correct number for the victim, Ms. Jagana, so that they will have that to reach out to her as soon as they can do that. But I want to go ahead and rule on it. It's not going to change the state's recommendation. And I don't know that it would change mine either. I know that she was obviously informed about this court date. And so in the essence of time, I'm going to go ahead and rule, since he does need a bond, and give him the $5,000 surety bond, $3,000 on the battery, $2,000 on the cruelty. Stay away from 8264 Millen Loop. No further contact with the witness, Miss Jagana, and no further contact with the child AJ. No drugs, alcohol, or weapons while on bond. And I believe that's it. Did I leave out anything, counsel?
No, Your Honor.
Judge, I would just, if I need to do a follow-up hearing on reconsideration, do I do that with you or Judge Dixon, who it's assigned to?
You file it with the clerk, and if he has not bonded out, he will come back. As you heard earlier, the reset date is May 18th. So it can, as long as it's filed by that date, I can entertain, or whoever's sitting that date rather, will entertain it on May 18th.
Okay, that's just for magistrate court, correct?
This is state court. It's already been
I'm
accused
sorry,
and bound over.
Right.
Mhm.
But it
Already
is
been
assigned to Judge Dixon, is that correct?
For trial purposes.
Yes. So
Mhm.
all other matters are controlled by Your Honor?
Yes.
Okay, I'm sorry, I wasn't familiar. I mostly do
Yeah.
felony.
Well, and this calendar, if you're not familiar, this is a newer calendar. I say
Right.
it's somewhat new. I think we've been doing it since, I don't know, November, December, October. It's longer than we think, but this is a little different. And the
Yes,
case
ma'am.
has already been accused, bound over to state court. And so this is this expedited accusations calendar
I understand.
that we're doing now, and through the state court. But you can get it filed with the clerk. I think you can e-file it online, as far as I know. And then if he's not out by the 18th or before, then it can be taken up on that date.
Will do.
Okay.
Thank you.
All right. Thank you. Who do we have next, Deputy?
Position 5.
Mr. Jagana, excuse me, Mr. Jagana, call me when you get out, okay?
Okay,
I'll let everybody else know.
all right, thank you.
Thank you.
And Your
Thank you,
Honor, Ms. Duncan will be handling the remaining of the cases.
I'm sorry. We
No,
have
not a problem.
Okay.
So she has all the information. I will be here in the background in case she needs me. So she
Okay.
has my information so she can reach out. Thank
good.
you.
Thank you. And thank you for that with Ms. Corley.
Not a problem. Ms. Corley said she actually thinks they can do it by Friday morning. I just kind of gave Monday as a grace period.
Oh, okay.
Yep.
Deputy, please forgive me. Can we go ahead and take this case, since Deputy Falk gave us the information we were waiting on? The other one that we had in the breakout position, 8.
Yes,
Mr. Quiggle,
Jones.
Quiggle Happen Jones.
yes.
Thank you. This is case number 23 CR 002772F. This is Seth Quiggle Jones, charged with 2 counts of criminal trespass. The offense date is May 3rd, 2023. And I understand pretrial first arrest.
Yes.
Okay.
Who was it?
I'm sorry.
It was a SOB jail recommendation.
Okay.
All right.
All right. Stay.
Yes, for this case, as we previously discussed, there was an incident at the incident location of one
We don't
moment.
have to repeat it. We can go forward with it. I'm familiar with the facts as we've already discussed it pretty extensively in the breakout room. Just tell me what the state's recommendation is.
Yes, the state's recommendation in this case is $1,000 total surety, 500 per count, no further contact with the victim. In this case, Heather Quiggle or the witness Gerald Knight, names previously stated for your honor and spelled. Stay away from the incident location located at 10365 Plantation Bridge Drive. And reset to MHC.
Okay.
Your Honor, we would just say, I understand,
Uh-oh, you went out on me, Mr. Bartels.
hear me
you're
now?
back.
Okay.
Now we can. Okay.
I can understand the court's concern about him needing the evaluation. We understand that's going to be a condition of bond, but we would ask the court to specify no further violent contact. If he is evaluated tomorrow and then released, that's some cooling off period. And again, his mother is okay with him him being back in her residence as long as there is that plan in place to locate another placement.
And we also would like to sound for her because I do believe she is here.
I see her on the screen. Miss Quiggle, would you like to briefly address the court?
Sure. Yeah, I mean, I'm in agreement with what was stated.
Okay. All right, that's fine. Do you have any fear of your son coming home?
I think that, with a cooling off period, it'll be fine as long as he doesn't show anger towards me, because I haven't seen him really since this. Just as long as there's help on the way. Like, I was really under the impression that this was a referral for mental health, and we really do need that so much.
Right. Well, we're trying to do that, but the court does not move with lightning speed, especially as much as we would like. We try to do that. We do have a lot of cases in this county. So we have the court scheduled, but you can only imagine that there's certainly not as many slots as we need on each of those court dates. But we have received information that he can be evaluated by the MH court by Monday, but probably tomorrow.
Okay.
And so there will be, once he's evaluated, some type of plan in place. However,
Okay.
we want to also make sure with that plan that, like, as you stated, there is a cooling off period. The court is very concerned about that, and that you are safe, and that there won't be any additional incidences by sending someone back too soon. I think there was another person in the home, Gerald Knight.
Yes.
So we want to make sure that things have truly cooled down, and that your son gets the assistance that he needs, and in the right and proper time. And sometimes that assistance does not come overnight, and it needs to have a little bit more time than 24 or 48 hours, so that the court is sure that everything will be okay for the most part, or will start to be okay. What I want to do so that your son gets this evaluation by Monday, no later than tomorrow, the next day, just never know what may happen, is I want to give him a surety bond so that he can get that evaluation. We've talked to the MH court director who runs that court, so we were able to email her while we were in the breakout. So we can assure you that it's going to happen. So with this surety bond, he would stay in. I'm putting something on this order that you are not to bond him out before he gets that evaluation. And that is, again, for the safety of you and other parties involved. I'm going to also order that he not return to the home until we know that there is a plan in place so that he will have all the things that he needs, and whatever MH court orders, that will be able to be put in place, and a plan will be in place before he were to possibly come home or go somewhere else. They may find placement for him somewhere else. But we do need a couple of days to make that happen. Okay?
Your Honor, just to clarify, would Ms. Quiggle be able to work on posting his bond? Or that's done, but the understanding is he actually can't be released until that evaluation.
I'm sorry, Mr. Bartels, I'm getting every other word for some reason.
Sorry, Your Honor. So would Ms. Quiggle be able to start working on posting his bond? He just wouldn't be released until that is done? Okay.
Correct. Yes, she can start working on it. Yes, getting her application in and getting things in place. That is fine. I just don't want her to completely bond him out. She can start working on it, have everything in place. And once she gets that information, then she can call them back, call the bonding company back. So right now he's on a $1,000 surety bond. And it is to also stay away from 10365 Plantation Bridge Drive in Johns Creek, to have no further contact with the victim, Heather Quiggle.
That is until there is a plan.
And of course, Ms. Champion, until there is a plan in place with MH Court via the MH eval, that will be done in the next couple of days. And you can even put in the order confirmed with Ms. Corley.
And the witness as well, Your Honor.
Oh, I'm sorry, yes. And no further contact with the witness, Gerald Knight, until and when there is a plan in place for their safety of the two victims.
May I
Did I-
ask a question? Oh, sorry.
One quick second. Did I say no drugs, alcohol, or weapons while on bond?
No, you didn't say that yet.
Okay, we'll add that. And I think that's all I'm going to say at the moment, except that I'm asking for the cooperation of our first witness, Ms. Quiggle, to allow this MH court eval to occur before completing the bond, and making sure that there is a plan in place for her safety and for the other victim's safety, Mr. Knight.
And Your Honor, just to be clear, are we still doing the reset to 511 if he's not bonded out, or 512 if he is?
Yes, and then the reset date would be 5/11 if he's not out on bond and Ms. Corley has not put a plan in place. And then if he is bonded out, then we'll still have him to come back on May 12th to that court for further instructions and a plan in place as to go forward.
Quiggle, I'll be in touch with you after court.
Okay, but the one thing I did want to ask is that he not be transferred to the Fulton County Jail during this period, considering the state that he's in and his condition. I just feel that this is probably a lot in light of everything that's happened recently and the traumatic events he's been through. That hopefully,
I think he's already there.
I think I was under the impression he was still in Alpharetta.
Alpharetta transported him to the county.
No, he's in courtroom 2, and that's at the Fulton County Jail.
Thank you. I was not aware. Thank you.
Right.
I'll be in touch with that.
Yeah, sometimes it's the numbers and the issues, but they have court there. So you can talk to your attorney about that.
Thank you, Your Honor.
All right, thank you. All right, who do we have next? Deputy Norris. Actually, we don't have to go in that order because Deputy Falk has left her information with ASG Duncan.
Okay, I was going to do position 5 anyway.
Okay, so we'll defer to you now.
Okay.
Could you
All right.
tell me the defendant's name as well when you say the position?
Okay, this is Joshua Jenkins.
Okay.
This is 23 CR 002767C. Mr. Jenkins is charged with one count of theft by shoplifting, offense date 2/21/2023. Pretrial.
He's been in custody, I think, since April 25th for other shoplifting. He was out on pretrial, but those bonds were surrendered. He got a 2021 theft by deception conviction, 2021 theft by receiving conviction. He got an open burglary in the first and second degree in DeKalb County. That's it.
Okay. Stay.
Yes, Your Honor. As pretrial has stated, this defendant does have 8 cycles with 2 previous arrests for theft by shoplifting, a 2021 conviction for theft by deception out of Cobb, and a 2021 conviction for theft by receiving stolen property out of Cobb, and 2 arrests for burglary in the first. In this case, it did occur on February 21st, 2023 at the reserve list located at 6909 Roswell Road, number 415 in Sandy Springs. This defendant did enter that store and make his way to the rear of the business. When asked if he needed assistance, the defendant asked for a liquor, which was directly in front of him. Then the defendant was provided with the item that he had asked for and made his way to the register and walked around and quickly left. A Marcos Allard, that's Allard, the manager of the location, became suspicious and watched the surveillance footage, which showed the defendant stole a 1942 Don Julio tequila bottle valued at $174.99. The vehicle tag number of the defendant was captured and led to Farrah Jones, who told police she'd received several calls from the other law enforcement officer regarding shopliftings. And she stated that her car was being used as a rental and that the defendant was the person renting the vehicle. Similar thefts were reported from Cobb, Smyrna, Fairburn, and Johns Creek, including Fairburn, the theft of a 1942 Don Julio tequila bottle, the same as in this offense. Given this defendant's extensive history with theft-related offenses, as well as convictions and those burglary arrests, the state has concern about the risk of reoffense in this case, and we believe it may be a bit obvious at this point. So the state is going to be requesting a $2,500 total surety bond, a stay away from the reserve list located at 6909 Roswell Road, number 415. And no alcohol, drugs, and weapons, and an anti-theft course.
All right. PD Wills.
Thank you, Judge. Yes, Mr. Jenkins was recently in court on the 26th of April for a similar offense. He is 25 years old. He's originally from Georgia. He's employed at Anytime Trucking as a truck driver, where he has been employed there for 3 years. In the previous case, that was heard on the 26th of April, my client was issued a $1,000 surety bond, which he has paid, and he has received an ankle monitor for that. So we would ask for another $1,000 surety bond. The amount in this case is actually less than the amount of the value of the item from the 26th. And so that would be our request.
And again, as stated, Your Honor, the state does have that continued risk of reoffense given the nature of these offenses and the amount of times this defendant has continued to be arrested for theft-related and burglary offenses, as well as those previous convictions. We're trying to make sure that this cycle is, this defendant is held accountable. These multiple cycles indicate that there's an issue here, so we believe that $2,500 surety is more than reasonable in this case.
And I would just like to reiterate that my client has been incarcerated now for quite some time. So he's been incarcerated since last month, of course, obviously due to his own making, but he has paid penance in some regards as he has continued to be incarcerated.
Okay. I will order a $2,000 surety bond. I'm going to order to stay away from the reserve list, 6909 Roswell Road, number 415. no drugs, alcohol, or weapons while on bond. And that's all I'll order at this time.
Thank you, Judge.
Mhm. You'll have to talk to your attorney afterwards, Mr. Jenkins. Unless he has, yeah.
Yeah, I just wanted to ask them about the, like, if I pay the bond that day, like, I ain't gotta wait until.
You gotta talk to your attorney. She'll tell you.
Yeah.
Position 9, Ms. Rook.
This is 23 CR 002769F. Shelby Rook, you're charged with DUI, driving under the influence of alcohol, less safe, and driving following too close. The offense date is May 2nd, 2023. Pretrial.
Third arrest, 2018 false imprisonment, simple assault dismissed, 07 DUI NOLO.
All right. Date.
Yes, Your Honor, this offense occurred on May 2nd, 2023 in the area of Woodstock Road. Officers were dispatched to that location in regards to a motor vehicle accident at that location near Woodstock Road and Staple Run. Officers got to that location and they made contact with the defendant in this case. She was sitting in her vehicle, which was identified by the license plate, and it was located behind another vehicle, a Lexus bearing another, a Lexus, I'm sorry, bearing another Georgia tag. And there was front end damage to this defendant's vehicle from rear ending the Lexus that she was behind. She indicated that at that time she did not want medical treatment. However, she did appear to be intoxicated. Officers asked her for a license at that time. She went into her purse and provided the license to officers. Officers asked her to remove it and she did so, but her hands were unsteady in doing so and she fumbled a lot while trying to do that. Officers asked where she was coming from. She stated that it was her birthday. And officers asked if she had been celebrating. She stated yes. And then officers asked if she had consumed any alcohol, and she stated that she had. Once she said yes, they asked how many drinks, and she only replied with sake. And she was slurring her words, and officers noticed that she was having a hard time responding to their questions. And then when she was asked to get out of the vehicle, she was stumbling, and to the point where she was about to fall over, and officers had to catch her to keep her from falling over. Officers asked her, did she want to participate in standard field sobriety testing? She did not respond. She just put her hands up as if to consent to be arrested. And at that time, she was taken into custody. The victim, whose Lexus that was rear-ended in this incident, stated that she was just sitting at a red light, and then she was rear-ended by the defendant in this case. We do have a concern about the risk of reoffense in this case. This defendant does have 3 criminal cycles. However, she does have an extensive driver's history report with 24 total events on her record. 3 of those are citations for following too closely, and she does have that prior DUI NOLO out of 07, and there was an additional charge of DUI at that time that was merged with the NOLO conviction. Given this defendant's history with DUI and driving improperly, giving her extensive driving history report, the state is going to be requesting a $3,500 total surety. I'm sorry, not total, $3,500 on the DUI and $500 on the following too closely for a $4,000 total surety, no alcohol, drugs, and weapons, no further violations of Georgia law and ADT, and no driving. As Your Honor knows, driving while under the influence is particularly dangerous to the individuals while driving. And if the method and the means of driving become dangerous, it could also be dangerous to those others motorists on the road, as it was in this case, and it did result in a motor vehicle crash. So for those reasons, we think that our bond recommendation is more than appropriate.
All right. Mr. Bartels?
Yes, Your Honor. Thank you. Can y'all hear me okay?
Now we can, yes.
Trying to sit closer and speak clearly. I did
Okay.
talk with Ms. Rook about her case. I'm advised she's been in Georgia for over 10 years. She does work 2 jobs, Your Honor. Right now, she works as a caregiver.
You're going in and out on me again for some reason.
Okay, she works 2 jobs. I'm advised that she is a caregiver. She has a new job as a CNA, a certified nursing assistant lined up. And she also works as a cashier at the all used furniture store. And we don't have the benefit of complete discovery, but looking at the what we do have, it appears that there was no breath or blood test done. I imagine there's a body worn camera video, but of course we haven't been able to review that yet. And in talking with Ms. Rook, she did express that she very much regrets that she is before the court in this situation and wants the court to know that she does take this matter very seriously. I have the pretrial report. It appears that she would qualify for a pretrial signature bond. And given all of that, we would ask the court to consider a signature bond. If the court is not inclined to do that, we would ask for a $1,500 bond total, $1,000 on the DUI and $500 on the following 2 closely. I believe that would be sufficient to guarantee her appearance in court.
All right. Because there is history, I'm not inclined to do a signature bond, but I'm going to order a surety bond, and I'm going to order that in the amount of $3,500. That'll be $3,000 on the DUI, $500 on the following 2 close. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order an ADET and no driving except to go to work for medical treatment or to see her attorney and for court.
I am advised, Judge, that she's seeing a counselor. That would be covered by medical, correct?
Okay, if she goes to her counseling, yes.
And Your Honor, I would just like to add, the defendant in this case, as I stated, was asked to perform field sobriety. However, she did not. It's likely that officers would take that as a refusal, and because of that, her license is likely to be suspended. We would ask that no driving be subject to whatever limited permit she may be able to obtain through DDS as a result of this DUI.
Thank you for that.
Sobriety or a breath test?
I'm sorry?
I'm not seeing anything about field sobriety or refusing a breath test. I mean, of course, she would have to abide by whatever restrictions DDS does impose if they do anything.
Right. Well, I think she would have that administrative hearing. I don't know how that would play into it, but as long as she has a valid driver's license or limited driving purposes, those would be the only places I would expect for her to go. All the rest of the time, she should be at home just to go to work, medical and counseling, and to see her attorney or for court appearances. That would be the limited driving privileges while on bond. Okay, I think that's it. Anything else, counsel?
Nothing further.
How much was that?
3,500, 300 on the DUI, 500 on the following 2 close.
3,000 on the DUI, correct?
I'm sorry, 3,000 on the DUI and 500 on the following 2 close. 3,500 total. All right. Who do we have next?
And she had a question.
She'll have to ask her attorney.
Let's just,
Is it a question about your bond?
no, they did take me to the hospital where they gave me a breathalyzer, where they gave me a blood test screening.
shy of.
That'll be
Yeah,
fleshed out.
I thought they were taking me to the hospital because of the accident, and I was consenting to that and consenting to the breath alcohol, or blood test for the alcohol content. So I was consenting.
Okay. All right, thank you. Your attorney will take it from here, Ms. Rook.
Okay, thank you.
All right, thank you.
Position 1, Mr. Cook.
Joe, don't sit down.
This is 23 CR 0027771A. Matthew Cook, you're charged with 1 count of willful obstruction, 2nd count of misdemeanor criminal trespass and damage to property. The offense date is May 3rd, 2023. Pretrial.
7 total. Last arrest was 2022, 2 counts of simple battery, criminal damage to property. 2022 trespass, no low. The 2 counts of simple battery is no low. Simple assault, no low. 2018 battery DV conviction. 2019 battery DV arrest. Obstruction, crude 10 to 3rd, first offender. That's
All
it.
right. Stay.
Yes, Your Honor, in this case, the victim is a Mr. John Hamrick. That's John, common spelling, last name Hamrick. This defendant does have a previous case involving this victim, Mr. Hamrick. That's that 19 SC 165902. As a part of the original bond in that case, he was to have no further contact. This defendant also has another battery, family violence, cruelty to children in the 3rd case, 19 SC 166036, and that 22 SC 181319 case. These other cases do involve parties with the last name Hamrick. And just to make the court aware of the relationship as we know it between these parties, this defendant is the ex-boyfriend of the victim's wife. Her name is Zoya Hamrick. And one of those cases, convictions, is with Mrs. Zoya as well. In this instance, the defendant was at the location of Mr. Hamrick, which is 16012 Gardner Drive, and he was intoxicated and upset and becoming irate and proceeded to grab Mr. Hamrick's coffee mugs and smash them on the floor, causing them to break, and grab the home telephone that was at that location and slam it to the ground, causing it to break. In this case, Your Honor, we do have some concern, an extreme concern for the risk of reoffense here. This defendant seems to continue to have difficulties with parties involved in this particular family, as he does have that case that did involve Mr. Hamrick from Superior Court and does have other cases that involve this victim's wife. So we do have some concerns about the particular dangers to this defendant and his family, including his wife. We did not get a chance to speak to Mr. Hamrick himself. However, we were able to speak to his wife. She stated that she is afraid of this defendant. He is her ex, and she wants him to stay away from her, have no further contact, and stay away from her child. Given this extensive violent history between this defendant and Mr. Hamrick and his family, the state is going to be requesting a $3,000 total surety. That's $500 on the willful obstruction and $2,500 on the criminal trespass. Stay away from the incident location as stated on record previously. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. I would just like to add to the court that in that 22 SC 181319 case, there was an additional count of aggravated assault that was no pros. However, I believe that case did involve Ms. Zoya Hamrick. Nothing further from the state. I do not believe that Mr. Hamrick is on the line. However, we would like to sound for him. I do believe that Mrs. Hamrick was on the line, if Your Honor would like to hear from her.
Do I have anyone on the line, Mr. or Ms. Hamrick? All right, go ahead, Ms. McLeod.
Good afternoon, Your Honor.
Good
My
afternoon.
client is 54 years old. He tells me that he is gainfully employed. Your Honor, my client also tells me that he would need a one-time police escort to get back to the location so he can retrieve his belongings from that location. And he does tell me that he has somewhere else that he can stay. My client denies the allegations that are asserted in the warrant, Your Honor. And of course, he is presumed innocent. I would ask the court to give him a reasonable bond so he can get out of jail and get back on track with his life. Nothing further, Your Honor.
And just to clarify, Ms. McLeod, is he indicating to the court that he lives at this location?
That was my understanding, but he does have somewhere else that he can stay.
Okay, the court, I'm sorry, the state was under the impression that we didn't know why he was there. We were not under the impression he lived there, but given their history, we would just ask that there be no further contact and to stay away. However, we'll defer to the court.
Okay. I'm going to order the $3,000 surety bond with $500 on the willful obstruction, $2,500 on the criminal trespass. I'm going to order stay away from the incident location. I'm going to order no drugs, alcohol, or weapons while on bond. And no further contact with, would it be John Hamrick or Zoya Hamrick?
Both, he had previous cases against both of these parties.
Okay, and no further contact with either John Hamrick or Zoya Hamrick. And one-time law enforcement escort back to the property to retrieve any personal items that he may have there. Remember, Mr. Cook, you need to go back with law enforcement only.
And Your Honor, Mrs. Hambrick did request, it was brought to my attention that she did request he also stay away from her 15-year-old daughter. I believe she said that she's getting a TPO. I don't know if they share that child. I'm not sure of the dynamics, but I wanted to make sure I brought that up since it was brought to my attention.
All right, and I'll order stay away from her 15-year-old daughter as well. And do we have her initials?
Ms. McLeod, did you get those initials?
No, I don't have the initials of the daughter.
Okay, I think I can have our victim advocate try to reach out possibly and get those initials. We don't have them at this time.
All right, we'll just say her 15-year-old daughter, give or take. All right.
That's the only daughter. That's her only child.
Only child. Okay. All right. Thank you.
Position 12, Mr. Suter.
This is 23 CR 0027775J. Preston Suter charged with 1 count of battery family violence, 3 counts of cruelty to children in the third. Penn State, January 16, 2021.
Second arrest. He was arrested this year for a suspended license.
Okay. State.
Yes, Your Honor, I just want to make it clear for the record that these cases are within the statute of limitation and were accused with the appropriate tolling language that told the statute on these according to the public health covered emergency. In this instance, the first victim is Sonia Sutter, who is the defendant's mother. She indicated that on this date, she was returning from an outing with her child and other children, one of which is the defendant in this case. She stated that they were coming from actually Midtown Bowling. And there were 3 other children in the car who are minors, that's VN, LB, and ES. She indicated that there was a verbal dispute on the way home that turned physical very quickly when the defendant in this case started to strike his mother in the face, and she told him to stop the vehicle, but he refused to do so. When they got back to the house, she got out of the car with him. When officers arrived, they did see a deep cut on her upper lip. The grading unit did evaluate her on scene. And it was indicated by Ms. Sutter that she did spit on the defendant because her mouth was bleeding and she was trying to get him to stop hitting her in the mouth. Because her mouth was filling up with blood. She was able to identify the defendant based on a picture from his Instagram that was provided to officers. We do have some concern about the risk of reoffense. Given that this is his mother, we don't know the circumstances of the argument, but given that relationship, if he's able to quickly change in that way, we have some concern that it'll happen again. We were able to speak to her. She did indicate that she had to get stitches. She does not want to prosecute. However, that's why we have the concerns about intimidation. Given this type of relationship, we know that sometimes in these cases, when they're parent and child, parents tend to not want to proceed with prosecution of their child. However, we want to make sure that this defendant is held accountable for his actions, since he struck her so violently to the point that her mouth was bleeding and she did have to receive stitches. So for those reasons, we have that concern about the risk of reoffense and possible intimidation of this witness. So we're going to be requesting a $5,000 total surety. And if my math is correct, that is $3,500 on the battery family violence and $500 for each additional count of cruelty to children in the third degree. No further contact with any of the victims whose name or initials were stated on the record. A stay away from her home, which I think is not the incident location, but I believe her home is 1020 Lenox Park Boulevard. We'd ask that he stay away from there. 2 weeks of anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law. And we would like the court to sound for Ms. Sutter in case she is here.
All right, Ms. Sutter, is anyone on the line by that name? Ms. Sutter?
I think I see her, but I don't know if she wants to speak.
All right, you may go ahead, Ms. McLeod.
Yes, Your Honor, my client is 21 years old. He is the father of two minor children.
Excuse me. Oh, I'm sorry. This is Mr. Suter. I've been speaking to his mother. I don't know if she got this.
I cannot speak to you till I can see you.
Oh, I'm sorry. Let me fix that. Yes.
All right, and you are whom again?
Father.
Okay. And so we don't have you, he's not a victim in this case, correct?
No, Your Honor.
Correct, Your Honor. In fact, my client lives with his dad.
Okay, that's fine. Hold please, Mr. Is it Suter or Sutter?
Suter.
Suter. Let me just mute yourself and let me hear from Ms. McLeod
Yes, ma'am.
first. I may or
Yes,
may
ma'am.
not need to hear from you, okay?
Yes,
Hold
ma'am.
on a second. All right, go ahead, Ms. McLeod.
Yes, Your Honor. My client, as I said, he's 21 years old. He's working. He has two young children. He has a completely different version of what happened. He said that on this day, he was coming from bowling with his mom, his two children, and another minor child that she has. And his mother was drunk. And she started pouring alcohol on the children and on him. And he was just trying to stop her from hurting the children. He did eventually drop her home, and then he went and he made a police report about the incident, including photographs and everything of what had occurred, of the damage that she had done. My client is not in the least bit violent, but he is estranged from his mom, he tells me, and he lives with his dad. Your Honor, my client doesn't have a problem with no further contact with the alleged victim. He has no problem with that at all. They do not live together, and they were not living together at the time of the incident. He was just trying to have her sit, be around her grandchildren, and it just didn't go well. But he tells me that he was actually the victim in that case, that his mom poured alcohol on him and that she struck him. And I was able also to speak to Dad, who confirmed that that was what happened, because he was on the phone with his son and with Mom at the time when this incident occurred. I would ask the court to give my client a signature bond so he can get out of jail, get back to his life and to taking care of his 2 young children. Nothing further, Your Honor.
And Your Honor, the state would just say that we're not disputing Ms. McLeod's contentions. However, we're going off the information that was provided to us in the police report. The factual proof and the weight of the evidence will be proved at trial, obviously, but based on what was reported to officers, this attack did occur in front of 3 minor children, and the victim did indicate that she was struck so severely that she had to get stitches. So in this case, we do believe that our recommendation is more than reasonable. Nothing further.
I'd like to point out that my client actually went and made a report about the incident in real time, just on the day that it happened. And if we should go to trial, we would be able to produce that. Also, this incident happened well over 2 years ago. My client has not been in any trouble. I see absolutely no reason why he should not be able to get a signature bond to get out of jail.
And to clarify,
All right. I'm gonna hold off on that. I have heard enough information in order to rule on the bond order.
I think Ms. Suter, I'm sorry, Your Honor, Ms. Suter, I think she's trying to speak.
Miss,
Your
cannot
Honor.
hear you, cannot hear you.
I tried to tell her, she texted me, I'm trying to tell her to unmute.
You're on mute.
Okay, there we go. Sorry about that. I was having some issues.
Hold on. First of all, I'm not giving you permission to speak, so I need you to hold on. I don't need to hear any more information. This is not a trial. I'm going to go ahead and give my ruling on the bond. And I think I have a clear enough understanding of the allegations at this point in order to rule on the bond, okay? And so, Ms. Suter, I understand you may want to address the court, but I have 2 questions for you, and those are only 2 questions that I'm going to ask right now because I do not want to have a long hearing based upon the facts, okay? Because I'm not going to belabor the facts. That is not the purpose of this hearing today. The first question I have is, are you in fear of your son, Preston Suter? You're still muted, okay?
No, I'm not.
Okay, and he does not live with you, is that correct?
That's correct.
So tomorrow, the next day, or whenever, you would not have any interaction with him. Is that correct, since he doesn't live with you?
That's correct.
Okay, those are the only 2 questions that I need to hear today.
And Your Honor, I have a question just for the record, since she is here. Ms. Suter, just one quick question. On the day in question, do you remember telling officers that your son struck you in the mouth?
Yes.
And do you remember this morning telling our victim advocate that you had to receive stitches for being struck in the mouth?
Yes.
By your son? Thank you.
Yes.
Nothing further.
All right, thank you. Any cross-examination, Ms. McLeod?
No, Your Honor.
All right, thank you. All right, I'm going to order the $5,000 signature bond, and I'm going to order that signature bond through the jail. I'm going to have that breakdown, Ms. Champion, to be $3,500 on the battery and $500 on each of the cruelty charges. So that should total $5,000 SOB jail. I'm going to order to stay away from the 1020 Lenox Park Boulevard. I'm going to order no further contact with Ms. Suter. And the kids are the defendant's kids, correct?
2 of them, Your Honor. I think one of them is her kid.
Okay, so which kid is Ms. Suter's child? The initials?
I believe ES.
ES, all right.
Is that correct?
Is that
no,
correct?
it's not. It's VN.
Okay, VN.
VN, I'm sorry. And no further contact with VN, which is Ms. Suter's child. The other two children, LB and ES, are his children, correct?
That's correct, Your Honor.
And so I'm not going to order no further contact with them, just VN, which is not his child. No drugs, alcohol, or weapons while on bond. Anything else, counsel?
Thank you, Your Honor. The state would just like to place its objection on the record to a signature bond through the jail in a battery family violence case where injuries are alleged.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may. Have a good afternoon.
Same to you, Your Honor. Thank you.
All right.
Position 6, Mr. Johnson.
All right, this is 23 CR 002786C. Octavius Johnson, charged with 1 count of battery against a female who is pregnant and a 2nd count of battery family violence. The offense date is February 28, 2023. Pre-trial.
Second arrest, 2020 suspended license.
All right. State.
Yes, Your Honor, this offense did occur on February 28th, 2023 at 390 Stovall Street, Southeast, number 2116 in Atlanta. The victim in this case is Brianna Jones. That's Briana Jones, common spelling. She stated that she had gotten into an argument with the defendant in this case, who is her live-in boyfriend, about his employment status. She indicated that the defendant in this case jumped in her face, pulling her by the arms and then pushing her onto the bed. He began choking her while applying pressure to her neck. Officers observed several lacerations and bruises to her left upper arm, and she complained about pain to her breast. At the time of this occurrence, Your Honor, Jones was 13 weeks pregnant. We were able to speak to the victim in this case. She indicated that her and the defendant are in a relationship and they live together, and that she is currently pregnant by the defendant with no other children. She stated that her and the defendant have moved from that location. There's a different location. She did not confirm what she had previously stated to the officers about him placing his arms or hands around her neck and applying pressure. She denies he was trying to choke her. She states that she doesn't even remember how everything happened, and that this has never happened before. And she stated that she wants to continue her relationship. However, the state does have concern about the risk of reoffense, given the nature of the relationship between the parties. And as you know, Your Honor, the cycles of violence in domestic relationships, we do have some concerns about intimidation in this particular case. In this case, Your Honor, the state is going to be requesting a $5,000 surety bond to stay away from 390 Stovall Street, Southeast in Atlanta. No further contact with Brianna Jones, and no alcohol, drugs, and weapons. Given the nature of the offenses alleged and the fact that officers were able to view visible injuries as a result of this attack, and the concerns about intimidation of this particular victim. And if Ms. Jones is here, the state would like the court to sound for her when appropriate. I'm sorry, no, stay away from that address because they no longer live at that address. However, they do have a different address. So we would ask that he stay away from their current address, which is 5206 Ashford Gables Drive in Dunwoody. Nothing further.
Okay. PD Wills.
And Your Honor,
I'm sorry, let me just ask, Brianna Jones, I just see that she got onto the
Yes.
Zoom.
I'm here.
Hi, Ms. Jones. I'm going to swear you in. If you wish to address the court, do you?
Yes, please.
Okay. I'm going to only ask you 2 questions, but I'll swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Are you in fear of Mr. Octavius Johnson?
No.
All right, and are you still residing with him?
Yes, yes.
Okay.
I would like to make like a small statement if possible.
I'm sorry.
I would like to make a small
Oh.
statement if possible.
Okay, go ahead.
Yeah, I just wanted to make it known, that I was definitely not interested in pressing charges, pursuing any charges. When I made this report back in February, I did actually call the non-emergency line because I didn't feel like I was in any like legitimate danger, and I didn't plan to press charges. I just wanted things documented, since I am pregnant, I did want, just in case of any like future custody issues or things like that. But I definitely didn't feel like I was in danger, and I wasn't aware of how the system works. He just started a brand new job, and things are going really well. He's also very, very helpful around the house. I'm now 6 months pregnant, so it would be very helpful if he was able to still be around.
All right, thank you. PD Wills.
Thank you, Judge. Mr. Johnson is 28 years old. He is from Georgia originally, and he has 2 years of college. This would be his first child, the child that is on the way. He is employed by Woodward Property Management as a groundskeeper. He's been there for approximately 1.5 months, and prior to that, he was employed by UPS. As it was mentioned, he does not have he basically has no criminal history. This incident occurred February 28th of 2023. For some reason, a warrant was not issued until April 16th of 2023. My client was unaware that there was a warrant that had been issued. My client states that this incident occurred when Ms. Jones became aggressive. It was during her first trimester of her pregnancy. They were engaged in a verbal altercation that began escalating. My client restrained Ms. Jones, which would be consistent with that upper arm bruising that she may have had when the officers saw her and spoke with her. However, he stated that he attempted or was trying to leave the residence, that he did indeed leave the residence, denies that he had any kind of physical aggression towards Ms. Jones, and that he stated that Ms. Jones stated that if he left the residence, that she would call the police, which she did in fact do. In light of my client's criminal history, I would ask for a signature on bond. Again, this incident happened over 2 months ago. There have been no other incidents. My client does not have a history of violence, and it is Ms. Jones' request, as she is pregnant, that Mr. Johnson return to the residence so that he can continue to assist and support her.
All right. I'm going to order a $5,000 surety bond. I'm going to order that it be $3,000 on the battery and $2,000 on the battery against the female who's pregnant, for a total of $5,000 surety bond. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to, since it has been some time, seems like there's been the proper cooling down, I'm going to order no further violent contact with the victim, Brianna Jones. I will not order the stay away. I assume that there will be no further incidences. That is all I will order at this time. Anything else, counsel?
Nothing further from the state.
All right. Thank you.
Thank you.
Position 10, Mr. Sims.
Can you hold on for 1 second, please? Hold on about two minutes, 2 seconds rather. All right. I'm back.
I think this is Sims, right?
Yes. Position 10, Mr. Sims.
Judge, you muted.
All right. This is 23 CR 002700F. And this is Mr. Tremaine Sims, and he is charged with 1 count of willful obstruction of a law enforcement officer, 1 count of disorderly conduct, 1 count of battery family violence, and 1 count of criminal trespass. The offense date is May 2nd, 2023. Pretrial.
This is 10th arrest, 2011 probation, 2010 possession of marijuana, no law. Everything else is old. That's it.
All right. State.
Yes, Your Honor, in this case, it occurred at 3220 Keenan Road. Officers arrived at that location and they met with the victim in this case, Catherine Smith, that's Katherine, who advised officers that her son, the defendant in this case, was heavily intoxicated, and that he struck her in the head with the blinds from his window. She advised officers that when her son becomes intoxicated, he likes to fight her and destroy random objects. She did indicate to officers that they live at that incident location together. When officers arrived and they went into the location, which is the room of the defendant, to try to speak to him, they observed him at his window. Well, they observed that his window was broken and saw him outside in the backyard attempting to run away and hide in the bushes. The officer that had arrived on scene, which was Officer Mraz, indicated that they ran to the backyard to detain the defendant since he was attempting to run before being questioned. They indicated that he had small fresh cuts on his hands due to the breaking of the glass. They noted that he did appear to be highly intoxicated. He told officers at that time that nothing had happened between him and his mother. His mother did indicate to our victim advocate when we spoke with her that they do live together at that location and that she believes he has an alcohol problem and needs some help. She recommends an alcohol and drug treatment and evaluation. She stated that this is not his first time acting this way. However, this is just the worst time so far. Officers indicated that after he stated that nothing happened between him and his mother, they came back and saw that the defendant had destroyed all of the windows to his room and destroyed the toilet top in the family bathroom located in the hallway. We do have concerns about the risk of reoffense, given the familiar relationship between the parties and the fact that they live together, and this defendant's history, given that he does have 10 cycles, even though they are remote, they do show a pattern of likelihood to not positively respond to the legal process. We do have some concerns about intimidation as well, given the nature of the parties in this type of situation. For those reasons, Your Honor, the state is going to be requesting a $4,000 total surety. That is $500 on the willful obstruction of a law enforcement officer, $500 on the disorderly conduct, $2,500 on the, let me just check something. I'm sorry. I beg the court's indulgence. One moment. I just want to check something. This is Sims. And yes, it says on the calendar, my apologies, I didn't catch this earlier. It does say battery family violence. However, it should be simple battery family violence. I believe a word was missing. So
Okay.
the state is going to be requesting a $2,500 surety on that simple battery family violence and $500 on the criminal trespass, making a total of a $4,000 surety. no further contact with the victim in this case, Catherine Sims. Stay away from the incident location, as this did just occur on the 2nd. No alcohol, drugs, and weapons, 1-day anger awareness, and an ADET per the victim's request, given the status of the defendant at the time of this incident and the observations of the officer.
All right, Bartels?
Yes, thank you, Your Honor. I did speak with Mr. Sims, review the discovery that is available. I do believe this would be, the simple battery would be the charge, as Ms. Duncan had indicated. The police officer's affidavit in the warrant does state that he did not observe any visible physical injuries on Ms. Sims. And my client is 43 years old. He was born in Atlanta, Your Honor. He's lived here all of his life. He does have work lined up with the temp service. He indicated that he was supposed to start that this coming week. His ex-wife, with whom he is still good friends, and his mother both live in Atlanta, so he does have ties to the community. And given all of that, we would ask for a $2,500 total bond amount. We would ask for $1,000 on the simple battery and then $500 on each of the other charges.
All right. I'm going to order the $4,000 surety bond. I'm going to break that down with 500 on the willful obstruction, 500 on the disorderly, 2,500 on the simple battery, and then 500 on the criminal trespass. That should equal 4,000. I'm going to order no further contact with Catherine Sims. Stay away from the incident location. No drugs, alcohol, or weapons while on bond. And I will order the ADET and any treatment that it recommends.
Thank you, Judge.
Thank you, Judge.
Position 11, Mr. Smith.
No. Yeah, just the first arrest, SOB jail was a recommendation.
Thank you. State?
Yes, Your Honor. This incident did occur on September 11th, 2021 at the Golden Star Package Store located at 5065 Old National Highway in College Park. Mr. Patel, the manager of the location, stated to officers that the defendant came into the store and stole a 750 milliliter bottle of Jack Daniels with a value of $40. The defendant placed the bottle in his jacket and then tried to pay for other alcohol with a card that was declined. The defendant then left with the bottle of Jack concealed and got into a blue Honda Pilot. Mr. Patel provided officers with the tag number of that vehicle. It's indicated that the defendant then returned to the store on the 14th, several days later, and Patel called the police. The defendant was identified through ID and told the officer that he had been stealing from the store and was sorry, but could not pay for the alcohol he stole because he didn't have any money. In this case, the state is going to be requesting a $2,000 signature bond through pretrial services, no alcohol, drugs, and weapons, and a stay away from the Gold Star Package Store located at 5065 Old National Highway in College Park.
All right, Bartels.
Hey, Judge. Well, before we get to Mr. Smith, Your Honor, I did want to revisit Mr. Sims. Would it be okay for him to get a one-time return with law enforcement to get his belongings?
Yeah, you went out on me. One-time return for what now?
One time, Mr. Sims, Tremaine Sims, the last case, can he have a one-time return with law enforcement to get his belongings?
Oh, yes, I will add that to the order. Did you get
All right,
that, Ms. Champion?
Thank you, Judge. Regarding Mr. Smith, we would concur with the recommendation for bond. This is his first This did allegedly happen back in 2021. He informs me that he found out about the warrant when he went to apply for a job, and he voluntarily turned himself in. So he is not a flight risk, and we would just ask for a signature bond. And I'm informed he hasn't been back to the location since then, and he doesn't plan on going back there.
All right. How old is he?
He's 25, Your Honor.
I'm sorry.
He's 25.
25. Okay.
25, yeah. And he is employed. He works 2 jobs. He is a forklift operator for DHL, and he also does contracting work for B&C Homes. I'm told that he has 2 children that he sees every day, and he has family in the Atlanta area as well.
All right. I'm going to order a $2,000 signature bond through the jail. I'm going to order to stay away from the Gold Star package store on Old National Highway, and no drugs, alcohol, or weapons while on bond. And I think that's it. Anything else, counsel?
Nothing else, Your Honor. Thank you.
All right.
Thank you so much.
All right. You're welcome. Good luck to you.
That's it in courtroom 2.
Okay. And I got your
yes.
other one. You said that was the medical reset till tomorrow.
Yes, position 7.
Okay. Sounds good.
All right.
Thank you.
Okay.
Position number 1 is a total of a $3,000 good bond reset to the SAP. Position number 2 is reset further notice defendant made bond. Position number 3 is a total of a $5,500 good bond reset SAP. Position number 4 is a total of a $5,000 good bond reset SAP. Position number 5 is a $2,000 good bond reset SAP. Position number 6 is a total of a $5,000 good bond reset SAP. Position number 7 is going to be reset C55 medical. Position number 8 is a total of a $1,000 good bond. It's going to be reset to the MHC court on 5/11 if defendant is still in jail, on 5/12 if the defendant made bond. Position number 9 is a total of a $3,500 good bond reset SAP. Position number 10 is a total of a $4,000 good bond reset SAP. Position number 11 is a $2,000 sign-on bond through the jail reset further notice. Position number 12 is a total of $5,000 sign-on bond through the jail reset further notice. Any questions?
Think you got it. All right. See you all next time. Everybody have a good afternoon.